So I see a lot of familiar faces here that I've known over the years with DMAR, even back when it was JCAR. So nice to see you all. I apologize for Marcia. I found out about this meeting during our interprofessional this morning, so I'm covering her all day. She is at the Capitol because late last night we found out 5 bills just on conservation easements are taking place this afternoon, and she has to be present for all of those for technical questions. And believe me, there's a lot of technical questions on conservation easements. So she's handling that. I was the HOA information officer, if I haven't met before, for the last 4 years with the division. I also handled subdivisions and timeshares. Now I'm the education, communication, and policy manager, so I do the rulemaking for the division for all the programs. I've handed off the HOA duties, but I'm still doing subdivision timeshares until our new person gets trained into that. And the new HOA officer, so if you didn't know, is Shanavi Johnson. So if you have HOA questions, they'll be directed to her. I'll give you some highlights of what's going on with us, but also just to run some numbers that I was able to pull that I did a presentation a couple weeks ago. Right now we have 45,833 brokers, 2,672 appraisers, 13,548 MLOs, 1,606 CAMs, and 7,973 HOAs that are registered. We really know there's about 9,000 plus HOAs, but these are the ones that are registered. So that's all still pretty relevant to what you guys all do in your business and what you're dealing with HOAs and CAMs and such. So what I've got is, what are we all doing? Well, have you all taken the commission update class already? Especially from these two wonderful instructors? Okay. So there's been a lot of rule changes, obviously. You know, everything from the D rules, and that is taking some work. I mean, it's a transition for us also in doing these D rules, because that initial license period, you know, we did this years and years back when we went from the calendar to anniversary, and now we're going back to everyone's license on a calendar year. Pretty much similar to what we do as attorneys, the same thing, except we're on a year basis. So we've had to do those new rules, and you know, with the initial license rule, I think you're all aware everyone's got to have, if your initial license, it's only going to be to December 31st of that year. And then we're going to this 3-year transition. Well, that all came out SB 17-215 out of the sunset legislation. And then what happened was we figured out that some people wouldn't be able to do the 3 mandatory classes, the ACU classes, in that 3-year period, or in this new shortened transition period. So we had got together the education task force, which is one of my task forces, and we came up with a transition course outline for providers to do. We have already, as of yesterday, have one that has produced that course. However, and Scott's going to talk on this in a little bit, there is pending legislation that will nullify if it all goes through, and we will not have to take care of everyone trying to scramble to get that transition course or 3 in there. It will end up being just 2 annual update courses during the transition period. So I think he'll talk a little more detail on that and where that bill is sitting right now in the legislature. So that's really important and could be a big relief to the practitioners if we get that all taken care of, which I'm hopeful that it will. The employing broker course, Rule A27. So we put together a task force because again, what came out of 215 was that there were a lot of complaints about supervision that employing brokers were not providing to the folks in their office. So based on that, the committee, the task force, came up with a point system. Have you all had a chance to at least look at that? Okay. So it's nothing we just pull out of a hat either. I did a lot of research across the country and ended up with nearly 20-some states that had this point system. And I even talked personally with many of the states to find out what works, what didn't work, where your problems were. You've had it in place. And we could have gone anywhere from Texas to 3,600 points, something like that, down to some states that had, and they had a matrix that I could not figure out at all with multipliers and everything else. And then we had states that had 10. So we ended up, doing a nice compromise for 50 points. And it takes into consideration a number of things, the transactions, as well as property management transactions and education. Now, that bill is technically effective January 1st, 2019. But this is the opportunity for people, if you fall in one of the categories where you're not, quote, grandfathered in, you're able to now build up those points. So when we get to January 1st, 2019, there won't be any problems or concerns. We won't have to pull any license of any employing brokers, anything like that. So, and of course, we're going to make it as easy as possible just because we want a smooth transition and we don't want a shop closed down and all of a sudden people are scrambling what to do. So we've got this period of time to work this all in, and we've created the outline for the employing broker refresher course. It's going to be 4 hours only, and actually it'll be a really good course just for anyone that's an employing broker to catch up on some of the main subject areas, especially supervision, escrow accounts, everything else that'll really help in your business. So right now, the education providers are creating that course. My understanding is they'll have them ready to roll out probably May or June. So we're sitting good with that. We're way ahead of schedule. That's what we're trying to do. Any questions on that employing broker one? I'm sure there might be. Or you can always get a hold of me. Yes?
Gary, not on the employing broker one, but on the number of brokers that you say you have licenses of, the 45,000, are those all active?
No. No. And when I pulled that number just from my email from last week, I believe there's around 36,000 active. Roughly. Now this is roughly, but I can get the accurate numbers for you if you like. Forms, I know these guys are going to talk on forms, probably pretty lengthy, right? And
that would be my guess.
And so I'll defer to Damien on the forms. Some other programs that affect you though, the CAMs. I don't know how you work with CAMs, good or bad, but they are regulated. We are only one of 9 states that regulates or certifies CAMs, Community Association Managers. And if there's an HOA and it's professionally managed, you're going to be working with or dealing with CAMs. If there are no professional managers, which we estimate are about 30 to 35, maybe even a little more % of the HOAs have no professional managers, then you'll just be dealing with board members and doing that. But the CAM bill is the CAM program was up for sunset also. And that one is coming up. There may be something tomorrow on that. It's either going to be tomorrow or early next week. And the recommendations are pretty much to keep the program going, trying to fine tune some of the delegation of authority that they have. Try to work that apprentice license a little better. Right now, if you have an apprentice license as a CAM, we require that someone's basically with you at all times if you're making any sort of decisions. Because you can imagine if there's an apprentice at a board meeting, they may not know what to say or even what area they're talking about, because for an apprentice, they need no education. They just need a background check. So we're going to try to work on that a little better and see what we need for supervision on that. But that bill is in appropriations as of today. I do know that in the House, and it will be going over to the Senate pretty quickly, I would imagine. But it looks like that program will stay in effect, so there won't be any issues there. MLOs, that also has a sunset bill. We have a new public member. I don't know if any of you attend the MLO meetings. We have one next week for mortgage loan originators. And Dana Falbo is the new public member of that board. So she will be starting in effect next week. Appraisers, I know you deal with appraisers, same thing. I am the one drafting the new rules for the appraiser program, which is not the most exciting thing to do, but it's because of the new qualifications for appraisers. So the Appraisal Foundation, trying to get new members, trying to get new blood into the profession for appraisers, came up with lowering some of the qualifications, lowering the mandatory education that was previously required. So we have to incorporate all that in, and we're doing emergency rulemaking on April 30th because the federal law kicks in on May 1st, and then we'll go to permanent rulemaking probably the week after. I'll start that. So that gives an idea of the various programs we're working on, as well as, if you didn't get a chance, the HOA annual report just came out last week, so Sinead Johnson put that one together, and that will give you more information than you ever wanted to know about HOAs, details, where they're located, where the complaints come in, everything else. Now, one thing Marcia had with some notes that I had from a few weeks ago was common complaints we're getting at the division. Property management, three-way reconciliations, missing funds, not fulfilling the terms of the agreement. Entry only, performing brokerage duties but not, quote, acting as broker. Failure to disclose material facts. Criminal convictions, not reporting those. Not reporting criminal convictions. Teams, restricted to one brokerage by rule. The team is not its own independent brokerage. So that message has to get across a little better on dealing with that, as well as in just seeing the investigators and talking to them, team advertising. And again, people need to know who's standing behind the team, what is their, who is backing them up. So that's what we've been seeing. If you've gone to a meeting lately, a CREC meeting, they're getting longer and longer. So we do them by webinar, so you might want to listen in, but they're going for hours. The last one, gosh, it went till like 3 o'clock or so. I mean, we start early. So a lot of complaints come up, a lot of licensing applications come up, but that issue kind of crosses the board. The criminal convictions, as well as new licensees who are not reporting previous criminal convictions. And actually, that's happening across the board in a lot of our programs, MLOs, as well as appraisers and such. So people kind of forget they did something wrong, and it's better to disclose it. We can always deal with it.
Are those not picked up at all by CBI?
They are, but they are. However, if they don't disclose it, it's a violation for the licensing, and then we can let the board look at those issues.
They don't pick them in pre-licensing necessarily?
No, they'll come in pre-licensing too.
Okay.
Yeah, especially at the MLO program, because if there's anything that's a felony or that's even a misdemeanor fraud related, you don't get a license. They're under the federal, so it's pretty strict. I'm trying to think what else I had for, I mean, that's kind of it for legislation. I know you guys are going to touch on a lot, but I can always pop back in if I think of something else that I missed or, yes, John?
Can you speak, and if you don't want to, I certainly understand, composition of commissioners, and obviously there's been one change here fairly recently, and changes that are coming up. Reference members of public versus maybe 6 attorneys applying for the next vacancy, whatever. Just can you speak to that at all? Pardon?
What's wrong with that?
Like I said, if you want to avoid that, answer right. Sure.
I honestly do not know who has applied for the 2 positions that will be opening. I haven't been privy to that. I really think that what will happen is those applications will probably go to the governor after this next board meeting is over, so they can be in place for the June meeting. That's how it's been done in the past. But honestly, the only one I've found out was a new MLO, so that's all I've been privy to. But I have no idea on the composite, other than the statutory where someone must have the property management experience, and the lady from, the broker from Colorado Springs. That's the only thing statutorily that's there.
I think my concern is certainly, by having a number of attorneys on the commission, more than one, certainly has a little bit of inherent bias there that I don't know that's really good.
I know where you're coming from, John, and
it's more politely put that.
yeah, and it could, and it could depend. I mean, when I practiced in little Minnesota town, they used to say, "Gary, we never thought you were an attorney. You're a businessman who happens to be an attorney." It depends on the personality too, and how willing they are to work with the brokers and such. So I honestly don't know how that makeup's going to be, or who's even applying, or anything.
Okay.
But I see you enough, so once I do find out, yeah.
Hi.
Word up.
How's everybody?
Good.
So I don't know what order we were going to go in originally, but we do a lot of stuff together and would be talking over each other a lot, so I figured we could just ham and egg things.
The only reason we talk over each other is because I'm right, you're wrong, and
You're right.
we have this little...
Good point. But I'll start, just in kind of my notes, it was kind of leading into John's question, and maybe I can be a little bit more candid. I'm sure Damien will be pretty candid as well. Damien, full disclosure, is a real estate section council member.
Yes.
Which means that he is the source of all of our problems on commission applicants.
Yes, that would be me. Thank you for
That's
that.
that's a complete joke, actually, because it's been, I think it's been a good relationship between the Bar Association and the Realtor Association to some large degree because of Damien and my relationship and our ability to kind of, help work things through. And so
I agree.
I'm hoping that continues to go forward because I do think it's a great benefit. And it hasn't existed between CAR and CBA for a lot of years, going back probably even before, I would say, the 50s when Conway-Bogue was decided. But anyhow, John, to your point, and where I'll start, is commission seats. There are two of them that become available at the June meeting, as Gary was alluding to. One public, one licensee. They are not realtor seats. They're licensee seats, and we're fortunate to have a lot of good realtors that have participated through the years, but they are licensee seats at the end of the day. The two public seats are, and maybe some of you have heard me say this before, they're statutory and they're meant to represent the consumer public, and they have been filled by attorneys. And I mean, both, Julie's one of the smartest people I've ever met. She's an incredibly smart attorney, incredibly well-intentioned, and so is Rich. They're both very, very good attorneys. They're very capable, very qualified, and they're very well-intentioned, I believe, both of them. But I do think and maybe this goes to your point, John, there's a perspective that doesn't fully represent a true consumer or public member.
I would have never guessed.
Yeah, and it's because they see in their everyday lives, their perspective on a real estate transaction are either the most complicated transactions or the transactions that blow up and people are suing each other over. And so they see the worst of the worst and the toughest of the toughest, and I just don't know that fully represents the public perspective.
No, I agree entirely.
Yeah.
Absolutely.
And so to that point, the public seats are public, and the challenge that I've heard even Marcia speak to is the fact that it's not as if that there are a line of public members trying to get onto the real estate commission. So you can't be licensed, and you probably don't have a lot of tangent to the industry, but you are probably somebody that is maybe an investor, a real estate investor, somebody that's bought and sold homes, a number of transactions for your personal residences, maybe some investment properties, been generally involved, and is maybe most importantly, somebody that is willing to be a bit of a policy wonk when it comes to real estate commission rules and regulations, when it comes to licensing investigations. And Gary alluded to this as well, one of the things that's changed, I think over the course of the last couple of years more dramatically, is the length of the meetings has gotten longer, but in conjunction with that, the commissioners' preparation for those meetings have gotten a lot longer. I've spoken with a couple of the commissioners, and Chris McElroy, who's outgoing, I remember him remarking at some point in time that it had gotten in his last few meetings to a point where he was spending 50 or 60 hours as a commissioner to prepare for the meeting. and just reviewing all of the cases and all of the licensing matters and complaint matters that they would have to review. And so it's a unique individual that would be interested in that. But I would encourage you guys to be thinking in your lives, if you have clients, and this is a bit of a short fuse on this because as Gary alluded to, after this April meeting next month, whatever applications are there are going to go to the governor and then get kind of vetted out and interviewed, I would imagine, by, who interviews the candidates, or is there?
Marcia does meet with them.
So there'll be some interview process that goes on. But if you have people in your lives that would maybe make good public members or be willing to participate in that process, I think it would be really nice to have more of a true public perspective or consumer perspective on the commission.
No, I agree entirely. I do think that the attorneys that are on the commission right now, like Scott said, are well-intentioned. But it's difficult when there are attorneys that are used to doing things a certain way, of reading everything and writing everything and doing all this and micromanaging everything that they do in their professional lives, and then to get on the commission and it's supposed to be the Division of Real Estate that does this, and it's supposed to be the Forms Committee that does that, and it's supposed to be the Education Committee that does this, and it makes for challenging times. And I do agree with Scott that they don't have perspective of the run-of-the-mill real estate transaction where the brokers know what they're doing, get the transaction done, and nothing happens. All they see is the ones either at the commission or in their professional lives where something goes wrong. So that's the perspective they seem to bring.
Yeah. So think about it. Think about who you might know that might be potentially interested in something like that, because it would be nice. And then, of course, the licensee seat. I know there are a couple of public applicants, and I know there are at least a couple of licensee applicants as well. But I don't know how deep that pool is, and neither does Gary or anybody else for that matter. And I guess we'll see what happens over the course of the next couple of months by the June meeting, theoretically. Although Carol Ann Rogers didn't take her seat until was she there for the June meeting?
There was something that happened that she got. I don't think she was there.
I don't think she had been appointed by the June meeting last year. So
something happened that it got delayed.
Anyhow.
But with the workload.
Sure, absolutely.
Particularly with two out.
Although one less voice at the table, or two less voices at the table, might make it a shorter meeting. There was a meeting that was a year or a year and a half ago maybe, where literally the minutes took in excess of an hour to approve, from the minutes from the previous meeting. So anyhow. The other thing I was going to mention real quick, and then I'll let Dane, you maybe want to talk about the rule review stuff that we're working on.
Whatever, go ahead.
Just real quickly, our regulatory policy committee, so we formalized at the November CAR meeting, Board of Directors meeting, formulated a regulatory policy committee. It had existed in some form for probably about a year before that, and prior to that, we were sort of trying to figure out how to take positions on stuff related to primarily division stuff. It actually, when we started trying to figure out how to take a position, it came up in the F7 discussion that occurred almost 2 or maybe just over 2 years ago now. And so CAR kind of was like, well, how do we start really taking formal positions on stuff that's going on at the Real Estate Commission? And so in response to that, we started running that stuff through LPC, through our Legislative Policy Committee, which wasn't a terribly efficient way for us to make decisions, and also doesn't convene year-round. So we did formalize a Regulatory Policy Committee, and the charge of that committee is not just Division of Real Estate, although that is primarily our focus and how we schedule our meetings from, which are bi-monthly, and they track on the Real Estate Committee Commission meetings. But we also are charged with looking at potentially Division of Insurance stuff, Board of Mortgage Loan Originators, those other areas that might, we'll call tertiary areas to the real estate. And so I think that's been an incredibly productive committee, and it's forced us to analyze a lot of issues and get out in front of things and have a little bit more feet on the ground with that. So I think that's, I don't know, I just want to give you guys an update on the fact that was formally created at the October Board of Directors? October. We change them every year. It's a different month. October CAR Board of Directors meeting, and so that now exists in. So I was going to go on rule review, but you're just as informed, if not, in fact, you're more informed than I am about that. But the CREC rule review?
Yeah, so the Real Estate Commission legislation said that they had to go and review all of the rules, and Gary would probably know better than me, but essentially they're supposed to put it on a schedule as to when they're going to review all of the rules that are within each of the programs. So the Real Estate Commission rules, the ones that are the A, B, C, D, E that you currently have, They're in the process of starting to review those and take out the things that are like when they talk about salesperson, which hasn't been around forever, or they talk about broker and they mean employing broker or the brokerage firm or the associate broker, and nobody knows which one it is. So that's kind of been on the forefront. It's going to coincide probably with recodification. So one of the things the legislature is doing next year is they're moving 1261, at least for real estate brokers, out of 1261. I think they're moving it out of 1261 and putting it somewhere else on its own standalone statute, which means that all of the statute citations in all of the rules will change. There's not supposed to be any substantive change when they do this recodification. It's just to kind of reorganize things because 1261 has become this catch-all for anybody that has a license, and it's just kind of been a big bloody mess. And so they're just trying to reorganize it. Part of that is the division has decided to do in conjunction with that this rule review to go through all of the rules that real estate brokers have and try and clean them up and make them make more sense, and so that people can read them and actually understand what they say, which would be unique and might put me out of a job. But other than that, it's a big project. Scott's been involved in it, and I think we're through one.
Yes, I got through my one. He got through one a long time ago. I got through one yesterday afternoon. So
it is a big process. It's I'm sure that you guys will be hearing more from Scott as we go through it, but it's kind of preliminary at this point.
Yeah, and I will certainly keep you posted as we go through that process. There has been a number of solicitations through Division of Real Estate correspondence to licensees requesting any input that any of you all might have related to rule modifications. So now is the time. If there is disclarity or other issues that you might have with any individual, literally any of those rules, A through.
Yeah, it'd be better if you didn't say get rid of all of them. That's probably not going to be too helpful.
Your opportunity there would have been to fight in the sunset review to abolish the real estate commission.
Right, exactly.
Sunset the real estate commission.
Yes.
But that didn't happen. And that wouldn't make sense for any of us, obviously. But if you do have input as stakeholders, they've solicited at least 2 or 3 times. And when we were talking with Natalie and Eric,
right,
they were saying, I mean, they had some feedback. But you all are a great, you guys are very involved and pay attention to stuff like this. So I would encourage you to consider the rules in that context over the next several months as this process takes place. We're going to go for the next, I would imagine, through the end of the year at a minimum.
Well, originally it was supposed to go through the end of the year. My guess is it'll go through next year so that they can just do recodification at the same time and do the statutory changes. But I don't know if that's formalized yet or if they decide to do that or not.
And whether you submit those directly to the division or you want to contact me or Damien, I would assume, then happy to bring those changes to the table. But we're working through that now. Forms?
All right. I love forms.
Let me just hit 2018 real quick, and then we'll spend some time on 2019, because we've just had our Forms Committee meeting as of Tuesday, and I think everything's pretty much on the docket now, or is going to be on the docket, subject to a few modifications. But 2018, the one thing that did come up, as you all know, this SPD changed, and
Some people don't like them.
Well, we talked about this morning in a professional committee. It came up, and Bob Brown actually had asked the question this morning, have we gotten feedback? And Damien tried to blow through that by saying, it's all been positive. And I think I called him out and I said, no, it hasn't entirely been positive. Because I guess I'd be curious to hear, and I'm sure you would as well, do you guys have feedback to the new SPD? Anything? Like it, hate it? Clients don't like it?
In all honesty, it's almost a waste of time. Nobody's filling them in.
You mean because of the form change or because of the SPD generally?
No, the form change. I think it's a rotten form.
Well,
Okay, there you go.
I'll tell you what.
It's Damien's idea.
Yeah, this is my idea. It's all me.
I'm absolutely supportive of the clarification ever existing currently existing. I think that does clarify a lot of issues, but just having the yes checkbox, it's.
Well, I will tell you one of the.
Wonder what is being disclosed at this point.
I'll tell you one of my biggest concerns has always been with this SPD, and this is why it changed, and obviously you guys were in the class yesterday, but the reason it changed was because it was turning into the SPD as all of a sudden this acknowledgement or this warranty by the seller or some kind of representation that they're making within the seller's property disclosure, and that was creating problems because sellers are not supposed to be making representations in the form. They're supposed to be disclosing things that they find wrong. And I hear what you guys are saying about the fact that there's a lot of blanks in it. I certainly understand that. But at the end of the day, Colorado is still caveat emptor, which means that the buyer should not be sitting there in the due diligence stuff drives me crazy too, because people fill in all this due diligence stuff that they think that we're going to get from the seller because we magically put it in the contract, and all of a sudden the seller's not going to lie to us, and somehow we can use that against them. But the reality is that it's caveat emptor. And when buyers buy property, they should be doing every single inspection or investigation or evaluation or anything else that they feel they need to do to make sure that they are comfortable with the property they're buying, and not hoping that they inherit a lawsuit from the seller because they failed to disclose. And that to me is the bigger issue here. And if they aren't filling out the form, that means to the buyer, well, they're saying that they don't know anything that's a latent material defect, and if they don't know anything that's a latent material defect, it's incumbent upon us to make sure that we find them if they exist. And like I said, it just seems to me that we've tried to shift this responsibility, or buyers are getting this false sense of security that with due diligence and seller's property disclosures, that somehow the seller is responsible for telling them stuff that they may or may not tell them.
Is the Forms Committee at least looking at it?
We want to look at it for another 3 years.
Oh, my God.
Well, the reason is the commission put on a moratorium on any forms that we pass.
I know, but I thought this might be an exception to the rules, so to speak.
You know, you can certainly, well, if you think it's that big a problem.
It's not that it's a problem, it just doesn't do anything. It's just that not only are people not checking it, you know.
Well,
it's
here's my
a
question.
form, but some of it is confusing when it comes to structural things and whatever. It's almost conflicting in a couple of areas. I don't have one in front of me, so I can't give you a specific.
Well, I'd love to know examples. I'll tell you, we went through it, and for the most part, a lot of the categories did not change.
But I'm just, I'm just disappointed that sellers are just not filling it out. It just doesn't.
Well, let me ask you this, in all seriousness. If it was yes and do not know, and they just checked do not know instead, all the way down, instead of leaving it blank, would it change anything?
Yes, because they're acknowledging that they do not know. Because when it's just yes and a bunch of blanks, you don't even know if they actually read it. Or do they just sign it and send it back? Because it's blank.
So,
Buyers are like,
So
they didn't read this?
I think this is my take on it. This is what I tell people that complain about it, is that,
John.
although I'm scared of John. I don't want to.
Yeah, I'm a little too.
No, I know you're not. I asked the question. I mean, I solicited the question, and because it's important to talk about but I believe that part of the problem is I think the same information is there. It is a much cleaner looking form, and maybe the perception is then that a seller's not really paying attention because you have a lot of blanks in it now, versus having a very, very busy form that was either check boxes and all kinds of, on every single line in different places, or God forbid, which I know it happened a lot, a line drawn straight down through, I don't know.
Says do not know.
Which, by the way, is an affirmative representation. I mean, you're making an affirmative representation that you don't know, which I think creates, I would always caution brokers that that's the worst practice that they would allow their sellers to do, is say, I don't know, in a straight line down that thing. So I'm hoping that it's a that it's a transitional issue, and that once the market gets used to it and you start to receive it. The one thing that I will say that the most salient complaint that I've heard about it is that because the no and NA is not there, then things like an alarm system that before it would have said, no, there's no problem, or it would have said NA, in other words, there's no alarm system. Now it doesn't disclose, and this isn't the point of the disclosure anyhow, but brokers had come to rely on it, and buyers had come to rely on it as a notification of items that existed on the property
That they may not have known
that
about
they may not have
otherwise.
known about. And now, because there's no no or NA, then there's no reference. It's just a blank now. And so, to me, that's a bit of a salient complaint, but it is what it is. It will be. Where I was going with this whole discussion is when we made those changes, what we didn't do. I won't say because of who.
No, don't.
Not
wasn't
because of
me.
him or me, but we basically decided, and it was a mistake as a Forms Committee, that the commercial seller's property disclosure wasn't used, and therefore we didn't need one. Not even contemplating the fact that the commercial contract still referred to a seller's property disclosure, and it became a kind of a mess pretty quickly. And so we realized at the end of December that we needed one. And so really, Damien kind of jumped on that and recreated one, and we got, in kind of an emergency fashion, got the commission to bless at their last meeting the new commercial seller's property disclosure. So now there's the residential, land, and commercial. So the third one was just introduced. But in connection with that meeting, at the last meeting, the commissioners did mandate as opposed to a 3-year voluntary moratorium. In other words, it can't be more than 3 years, but you could go for 5 or 6 years. They did mandate that the entire suite of property disclosures are reviewed at the earliest applicable time frame, which means
3 years from January 1st.
from last January 1st. So it would mean Forms Committee would start looking at them again in 2 years, I guess.
I can't do math. I think
Anyhow.
that's.
So,
Yeah, I think
so
that's-
that kind of feedback, though, is good. And I do know that the global master list is something that the division keeps an eye on and brings that to the Forms Committee meeting. And if you guys have comments like that, then once again, it's
Yes,
important
absolutely.
to
If you want to call it a complaint, is it just doesn't give enough information to a buyer.
So you're saying that the buyer should be able to rely on something from the seller?
Well, yeah, but then why have the form? I mean, the purpose was to give the buyer some information
No,
rather than a 95% blank form coming back.
Well, the only point of the form, I'll tell you, was to disclose latent material defects the seller knew about. It's not for them to go through and guess on answers and things. And I'm not saying that your complaint is being unheard or anything else. I kind of agree with Scott. I think as this form gets used and people get used to seeing it the way it is and know that the sellers...
Maybe it's a temporary scenario where...
But if you do have concerns about it, to me, the 3-year moratorium is actually helpful because we can see if it's functioning or not. And if it isn't functioning, if there is still this problem, and it is something that we're like, wait a minute, the sellers aren't giving the information they should be giving, then we're going to have to revisit it on the Forms Committee. I mean, that's just all there is to it.
Yeah, but what I'm saying is sellers, when I go out on a listing and they're saying, I'm not filling any of this in, why are we having this? Sellers don't understand. And buyers say, here's a blank form, it's got 2 checks. Is it a member of an HOA? Yeah, okay. Nothing else. I mean, it's almost unreal.
Beth Ann?
It's not a blank form, because there are places where you have information the seller needs to input, like the source of water, does it have 220 service? And I get those, I mean, I teach, and I get complaints from the agents, they don't like it, because they're used to the other format. But when I explain it's a balance between the sellers sharing and the buyers, and it's kind of the best compromise in between the two. Because I agree with you, the other one was tilted a little bit more to the buyers.
Yeah. I mean, I think 3 years is going to tell us something.
My experience has been similar. I think the agents are all worked up over it. Sellers love it.
John is.
Because, well, and I've heard other people too, getting this point, but the sellers, they used to have anxiety about filling that over. I mean, they really did. They just didn't, I mean, it was so massive, and they had to answer every question. And you go back to, you missed number 16, you got to fill it out. So I think this is just more of an agent's anxiety thing. Sellers are just filling out what's applicable.
the seller can always decline to, in this market particularly, a seller can always decline.
To do it at
as long
all.
as they're doing it the contract. It doesn't relieve them of having to disclose in writing any latent defects, but it certainly would make the form go away for a seller.
I hear what you're saying, and like I said, I encourage if you see where things that aren't functioning in any of our forms, for that matter, send it to Gary, because Gary likes getting that stuff. But seriously, we as a forms committee, we look at what works and what doesn't work, and the reason that the form was created the way it was because of comments that we got back from attorneys that had clients sued over representations made in the form, and over sellers that were upset or buyers that were upset and brokers that had problems with clients after the fact, and that's why we came up with what we came up with. But that doesn't mean it's perfect, because that's why we get to change forms every 3 years, because they're never perfect.
Okay, so that was 2018. It was really easy. 2019, I'm going to mention one. So 2019, these are all changes that we'll talk about, and I'm going to let Damien drive this section because. Are you vice? Is that a formal position, vice chair?
Yeah, it is.
So he's formally vice chair, which is really an accomplishment considering the chair has been around since 1978 or 9, I think.
Yes.
So eventually, maybe Damien will ascend to the chair if Kent ever
Shut your mouth.
If Kent ever walks away from the. And Kent Levine has been chair, and Kent's a gem of a man, and he's done an awful lot of work on behalf of the forums and the brokerage community in general for a lot of years, and so. He just talks slowly. Did you pick that up in the back? But 2019, the one I want to touch base on is something that maybe you guys have all heard me harp on for the last couple of years, because it's been a problem, and I think we finally got it resolved. Oh, I was going to, just a caveat, all of these things we're going to talk about are subject, of course, to the Real Estate Commission's approval at the June meeting. So Forms Committee's all agreed on these changes. We're going to be submitting to the Commission, and the Commission will have their own thoughts on it, but I would imagine that the vast majority of these, with maybe a couple of exceptions, will probably end up being pushed through. And these would all become effective January 1st, 2019. But the only one, I'm going to lead with this, and then I'll just let him kind of run with a bunch of others, and I'll fill in where necessary. Lead-based paint. I'm so excited to tell you that lead-based paint is going to move to the dates and deadlines section now. It has been problematic. I can't tell you the number of contracts, and all of you practitioners know any pre-78 construction, I believe it's as high as 30, 40, maybe even 50% of contracts have not been executed timely based on what our contract says and are therefore void. And so that's going to get moved over to the dates and deadlines. Now there's going to be a lead-based paint delivery date that the parties are going to agree to, and then essentially a lead-based paint objection date that the parties will, or that the seller, or the buyer would have an opportunity to terminate the contract based on whatever lead-based paint review they do. So that's changing as of January, well, assuming the Commission adopts that, it'll change as of January 1st. And I think it's been an important change. I spent a lot of time looking at other states and seeing how they did it. And we were really kind of an outlier in terms of how we did it in the state of Colorado. And it's, I think, a really good change.
Yeah, he doesn't say enough. He actually went and researched like 29 different states to find out what they were doing, then drafted the language. And for Kent Levine, who has been on the Forms Committee since 1978, it takes really convincing for him to change provisions of the contract. And Scott had to show him the law and go research the EPA and their standards and what they recommended. And I mean, it was a real big project, but to me, it's a real win for the industry because it'll finally make it so that you can deal with it. I will tell you, there is going to be a big liability that comes out of this for brokers, even though I think it probably existed before, is that if you're putting in NA in the lead-based paint disclosure box and they're pre-1978, you're probably the one that gets to pay the $16,000 fine if it comes up. So, so there is more that brokers are going to really have to pay attention to make sure they do it right, but I think most people know when it's lead-based paint. The problem has been when they get it signed and the counterproposal and lead-based paint comes over and they do the counterproposal first before the lead-based paint, and just problems like that. So
yeah, I think overall it's a great change, and I'm very excited about it. So anyhow,
and I think it's great.
You jump on whatever else you want to talk about.
Okay.
I'll chime in where necessary.
Okay, so I got a list of, so you guys got 3 years off from the contract, which means now we get to play. It's going to be so much, I look forward to this. I mean, you sit there for 3 years with all these great ideas, and then you finally, it's like a kid in a candy shop. You get to go and you get to play with the contract and do all sorts of things. I will tell you that the goal of the Forms Committee is not to recreate the contract every time that we do this. We're not trying to make it so that the industry has a whole bunch of brokers saying, okay, so now I have to learn a new form. But there were a lot of portions of the contract that were not functioning well. I'm just going to give you some examples. So the first one is 6.3 with lender requirements. So the way that lender requirements works now, as you guys know under the appraisal provision, is it says if there's lender requirements or there's something that comes up on appraisal, like the siding needs painted or the downspouts need to be attached or something along those lines, then if the buyer gives notice to the seller has 3 days to terminate. But the way that the contract reads currently, if they don't terminate, it seems like the seller has to make the repairs. And it's different from every other part of our contract where we have an objection and a resolution. And so this lender requirement is going to fit more with this objection resolution thing, which essentially says buyer gives notice, they go ahead and they can resolve it. If it doesn't get resolved by a date, then the contract terminates, which is more consistent with what the rest of the contract reads. I know from my personal experience that lender requirements has been difficult because most people don't even know it exists in there and thinks that the appraisal deadline actually dictates what happens on appraisal. Another thing that's been a big issue is association documents. I mean, I heard Gary talking about CAMs, and I know, how many of you here have never had a problem getting documents from an association? Right? So part of the problem, this is something that we've been researching like most of this year, trying to figure out how do we solve this problem. And it's more than just the buyers getting the information. This goes deeper. It goes deeper to title companies getting the numbers they need in order to fill out the closing disclosures, lenders getting information that they need up front so that they can process the loan. And the documents that we've been requesting in the form don't necessarily tell the full story. There was nothing about the fees. There's nothing in there really about the special assessments or construction defects or anything like that. But then you also have the issue of how much does the increase in the transaction costs are we going to have if we create forms or do something else? One of the first things we tried to do is create a form that would be done at the beginning, but the CAMs pretty much said that, well, if you create a form that we have to fill out, we just want to charge people $200 a pop to do it. So the solution that we came up with for a couple different reasons was associations have an obligation to have this annual disclosure. Annual disclosure, and Gary knows this stuff better than I do, actually. He's the one that helped me draft this provision. What it does is this annual disclosure says after every fiscal year within 60 days, you have to disclose certain things about the association to the owners. And this is stuff about last minutes, and what are the governing policies, and what are the bylaws, and insurance policies, and just everything. There's just this big, massive disclosure that they're supposed to be giving to owners anyways. And so what our document now references is that the buyer gets a copy of the last current annual disclosure. That way it's a free document that the seller should have that they can provide. There's also a provision that says that the owners are supposed to get notice of construction defect lawsuits. And so that notice is now requested for in the association documents. And then under Rule F6, there's a provision for CAMs, this is F6 for the CAM guys, that says that they have an obligation to disclose all of the fees that they're supposed to be paying, or that they were going to require to be paid for status letters, rush fees, all these other things. We're moving those up too, putting it in the association documents with working capital and transfer fees and all this other stuff. So this way the buyer can get information and object and terminate the contract under association documents. But also important with that is that the title companies will get copies of all these fees, and the lenders will get copies of all these fees, so you can actually put a closing disclosure together at the time it needs to be put together, instead of what currently is happening is 2 status letters are being ordered and everybody's paying multiple fees. So we're hoping this is going to be a fix. I don't know if we'll have to ask the Division of Real Estate if they can adjust the rule or not, but the point being is we're trying to figure out a way to get that information so buyers have the ability to object instead of finding out at the 11th hour that there's other fees associated that they didn't know about. So hopefully that one will go through too. I saw most of you guys have taken the commission update course already. So one of the changes also is going to be FERPTA. It's going to be added in 15.8, which is going to be something about FERPTA, which has an affirmative disclosure in there if the seller is a foreign person. The default is that they're not subject to the tax, but it also has things for title companies where if FERPTA is implicated, then the title companies have the rights to ask for documents and hold monies and do these kind of things, instead of having this fight at closing over what happens if it's a FERPTA transaction and what does the buyer have to do. We're hoping that that's going to have an impact on the title companies too, that for many years have had this bury my head in the sand approach and said, here, just sign indemnities, and that way if the tax is owed, buyer and seller can go figure it out after closing. So that's one thing that was added. We also threw in that paragraph about collateral withholding because it kind of is related. It has to do with that as well. The other issue, and this has been a pet peeve of mine for a long time, and I know it's one of yours too, is the stupid check boxes at the bottom of the contract. So ever since we went to electronic signatures, we have these check boxes at the bottom that say countered or rejected. You guys know what I'm talking about? How many of you have heard of or have been involved where the seller doesn't check the box and just signs the contract instead? Right? I get that call, and I know you get the call all the time, of probably once a week where somebody signed 2 contracts because somebody said you have to check the box and send it back to us. We're taking out the check boxes. At least that's the proposal, because it's not needed. At the end of the day, if the seller doesn't sign the contract by the acceptance deadline, that means it's not a contract. It was rejected. More importantly, if they do a new counter and send you a counter proposal, that means it was countered. So it seemed like these boxes, while in the paper days made sense so that you could track whether or not you had these things going on, just don't seem to make sense in today's day and world. So
the only potential concern with that was, I understand about the counter, but the rejected side, the initials there always was an affirmative response that the offer was presented and it was actually rejected by the seller. Whereas just hear nothing, you have no idea really if the offer was truly presented or not.
Well, here's the problem though, okay? The listing broker doesn't owe a duty to the buyer broker. They don't have a duty to present all offers and prove to the buyer broker that they presented the offer. They do owe a duty to the seller.
That's not the whole purpose. It was, we work for the public, we're working with the public, and it's their expectation. They want to see these situations. And, without those, without that check mark, I think that, the buying and selling public could lose confidence that, hey, it's all a shell game being done behind closed doors, and like I said, that's my concern.
Well, and if that's what's going on, is it's a shell game behind closed doors and their offer was never presented, then the listing brokers got problems because they didn't meet their uniform duties. And the reality is, I will tell you, best practices is you're a listing broker, you should be sending an email that says, hey, I just want to let you know we rejected your offer and we went with somebody else. I mean, that's just common courtesy to your fellow brokers to let them know that you presented the offer and this is what happened. The problem with the rejected box has been is that we've had, oh, hey, we decided to go with another offer. And, oh, well, you need to check the rejected box and put initials on it. Okay, so they go to their seller and say, hey, you need to check the box and put initials on it. They end up signing it, and then the buyer thinks that they're going to enforce the contract against the seller. It's created a problem because of the world we live in, and sellers, the problem is that sellers don't deal with electronic contracts. You guys deal with them every day. They deal with it once every 7 years when they buy and sell a house. And so they make mistakes by, checking boxes and signing things, and I don't disagree that the broker should be at least telling people that the offer was presented and it wasn't accepted and here's what we decided to do. But putting the checkbox in the contract has caused a lot more problems, and I see nothing in the license law that is a requirement that a buyer broker gets to get that back.
You also have issues where the listing broker, the seller makes a mistake and does something erroneously, and he and I disagree on what the implications of that are. But you also have, I get a lot of complaints through the hotline as an example of a listing broker saying, this buyer's agent won't leave me alone. They're threatening to file a complaint against me because my seller doesn't want to check any boxes on the contract. They don't want to reject. They don't want to, like I've told them they rejected it. They don't believe me. They're trying to file a complaint. So it puts the listing broker in an odd position of trying to mandate their seller to do something their seller has zero obligation to do, check a box in a deal that they're rejecting. So I think it's a very good change, and I do see much more problematic is the mistaken acceptance of a contract or an offer, and that occurs much more than it really should. And on that, I know there's some way in CTM that you can make sure that when your client takes an action on the contract, it doesn't immediately distribute that back out to the other party, because that's the biggest problem.
And that's a huge problem.
Party receives it, and then we won't even get into the argument that he and I have over whether you've got a contract or you don't have a contract, but that's...
Well, wait till it's litigated, then we'll see who wins.
Yeah, I mean, eventually it probably would, but at least those boxes are gone, which I think is a good change.
Yeah.
So shouldn't, if you want to try and mitigate that problem, shouldn't you look at where the signature line is for the seller to sign? Putting something in that's obvious, bold, do not sign unless accepting contract.
Well, there's a lot of ways for a broker to really stop it. I mean, for starters, you can check the box for it and send it so that it's not available to sign it. You can make it so that it goes to you instead of back to the other side so that they're not getting notice that the contract's been signed. I mean, there's a ton of ways to do it. The problem is everybody leaves the system in the default mode and whatever happens, happens, and sometimes it doesn't happen the way you want it to.
Or you can change it to a PDF so they can't sign it.
Yeah.
Yeah. I mean, there's a ton of different, and we could talk all day long about the limitations and the what's good and what's bad about CTM contracts or whatever electronic contract software you're using, but you do have to be careful because the limitation on a lot of these systems is it could have unintended consequences if the seller doesn't understand what they're doing.
Real quick, and are you going to touch on your 3.1 changes in the contract?
I wasn't going to, but go ahead.
Well, it kind of dovetails into the CTM stuff.
Sure.
I do think CTM is supposed to be changing within the next week or two, and you will hear it, or CTM users should hear it, that their default fill in a blank, if you check the box of default, it defaults to NA. They're going to change that to none very soon, within the next week or two. So, and the contracts 3.1 is changing a little bit, and it's more of an administrative shift to try and address some of that problem, because candidly, most brokers don't mean to be striking the entire provision when they put NA in a box, and that's what CTM has been doing to this point. But look for some notification from CTM over the next week or so that they're going to change that default to none.
Yeah. And the contract will be cleaned up too, so that it's not just a blanket NA
Yeah.
for everything. It's more in line with what it's supposed to do, which is NA and a deadline deletes the provision. So do we want to talk about title?
Paragraph 13?
Yeah.
Well, this is one of the things this is the one area that might change because
Yes.
there's some issues, and at the April meeting, we have a suspicion that there's going to be some members, interested stakeholders, will say, title companies, that will show up, or LTAC primarily, will show up and try and encourage that these changes get pushed back for another year, but in fact would be another 3 years based on our moratorium, pending some legislation that they might be proposing for the next legislative session, in which case, that's one of the exceptions. If there's a change in legislation that mandates a change in the form, then the moratorium goes away for that purposes of that change. So that gets a little bit complicated. We haven't even talked about that part of it, but
No.
anyhow, the one thing that, without getting into the deed thing, or the exceptions thing, what we have approved, or what Forms Committee has proposed, is now a checkbox. So now it won't be a blank warranty deed. It'll be a general, special, quitclaim, bargain and sale, and
I think they have other,
PR
but
or other. Okay, so
Yeah.
other blank. So now it's going to be a checkbox for the form of deed, as opposed to a blank warranty deed, which is there now.
yeah.
And then you go ahead. We can talk about the deed thing.
Okay, so the biggest thing, you guys have taken the update class. I'm sure that you've seen the thing about the exception deeds. So here's what's going on. In residential, real estate brokers tend to give general warranty deeds. And when you give a general warranty deed, you're giving away, the seller is giving warranties not only for whatever happened before, but to future buyers about the status of the title of this property. And the problem has been is that the title companies, when they prepare their deeds, they don't list exceptions in there, which means that future buyers, after the one you sold it to, could potentially come back to a seller for warranties that you gave because it doesn't list those specific exceptions. So a seller would actually be warranting the title more than they intended to for subsequent buyers after the current buyer. And the issue has been that because of this, the broker is the one that has the liability, because ultimately it's the broker that's responsible for preparing the deed and responsible for reviewing the deed and making sure that it sets forth. And as you probably have heard in the update class, that the title companies are supposed to be the broker's scrivener. And so the rub here has been that we have title companies that have been preparing deeds for a long time, and they do it a certain way for a certain reason. There's conversations about unauthorized practice of law and protecting plants and all sorts of stuff as far as motivations as to why they do what they do. But when they prepare these and create this future liability for these buyers, they're creating them on behalf of the broker who has the liability if it goes wrong. And they want to hide behind scrivener at the same time. I say this because obviously I have a slanted view on this, but Real Estate Section Council sent a memo to the Forms Committee and asked that they change Section 13 to specifically list the exceptions. This is actually a proposal from the bar, and that's why it made it into the contract to begin with. The Forms Committee did approve it, and we'll see what happens at the April meeting as to whether or not LTAC is able to convince people that it should be changed.
Are you aware of any lawsuits regarding a deed that didn't list specific exceptions?
Yes. I had a conversation with some title companies this morning, and they gave me 3 or 4 of them.
Please share it with me, because I've had lengthy discussions with John Goodman about this. I've never heard of one in his entire practice.
That's gone back on warranties?
On the specific exceptions to the deed.
Okay. So
Because I've fought with every title company, talked to every title company attorney, and insist on having the specific exceptions.
Right.
As an exhibit to the deed. And usually we win.
yeah.
After a lengthy discussion with Mr. Goodman, he's like, is it worth expending the energy?
Well, and that's the question, is whether it's worth expending the energy or not. And that's why the Section Council obviously feels it is. That's why they put the memo before.
You should ask John if he requires the same thing for his clients when he negotiates a
When he
deal.
represents a buyer, of course he does. And when you represent the buyer, you should have the specific exceptions in there. When you represent the seller, now the contract, I believe, does state the specific exceptions should be on the deed with the current language. That's my opinion. That's my
Mine
personal
too.
opinion.
Mine too. That's what it was meant to do.
But in point of fact, when you represent a seller, you're much better off with a blanket, right?
No, you're not. You're not, because actually the language in there says that the seller is taking it, or the buyer is taking it subject to those exceptions that the buyer agreed to on the Schedule A or the Schedule B2 exceptions. But because it doesn't list the actual exceptions, and because it doesn't, and when it used to say all those of public record, that was better. But the new deeds, this is what prompted the Real Estate Section Council to bring this up as far as a memo, was the new deeds say those exceptions specifically accepted by buyer, which doesn't list anything, which isn't a blanket all those of public record, which means that if I had 5 exceptions that I'm giving you a deed for, and you sell it to Heather right after that, that means if Heather's title commitment or title insurance policy doesn't cover it or whatever, and then one of these things comes up, she can actually sue me for those 5 because they're not specifically listed and they're wild documents. And wild documents mean if they're not a public record, if you don't say what they are, you're given warranties for more than what you thought you were.
Well, typically the deeds that I see say that they describe, is described in the title commitment dated such and such.
That means it's a wild document, you can't rely on it, which means that if it comes up,
I understand, but I'm still interested to know where we see a lawsuit never occurred.
I just know mine personally.
If you could send me a couple, that'd be great.
Well, I can.
And I'll continue the battle.
Well, I'll tell you what mine was personally. We'll do it some other time besides here. But I mean, I've actually litigated one myself, and I don't litigate. So if I litigated one, I'm sure there's more.
The point is you with this contract change, you shouldn't have to continue to battle because the contract requires that those specific exceptions are listed on the deed. So that might create some other issues, and that's what is going to have to be worked through with LTAC at this point.
And then the title company's issue is, well, we did all this research now. It's
Sure.
public record, so.
That's
Well, that's what that to me. And frankly, I don't really. If they want to leave the deeds the way they have them, I'm okay with that. But they should take the liability for them. That's my only point.
That's why it was going to be my question.
Yeah.
If the exceptions get into the deed, who in the transaction has the liability to make sure that they are the correct exceptions?
Well, the broker is ultimately responsible. The plan is in the contract would be those exceptions listed in the schedule, specifically list those Schedule B2 exceptions. And the point being is that you want the insurance to match the warranties that the seller is giving. So that way, if the seller is giving warranties, at least they're not in excess of what the insurance is that's covering the buyer, which means if you're a buyer, you're going to sue the insurance company. You're not going to go after the seller. You're just not.
And again, not that I'm anti-attorney, but kind of saying, okay, does that have to,
It doesn't sound like it at all, John.
does that have to go to an attorney to be reviewed?
No, and then the point of the contract change would be that it doesn't have to go to an attorney to be reviewed. Obviously, we should be giving that advice regardless, but I know that when it comes to consumers, we're buying the biggest asset in our lives, but why would we want to spend $25 for a CPL, or why would we want to pay for a survey, or whatever the case may be? And I get that. That's the limitation you guys have, because everybody seems to think that it's the brokers the reason that they don't hire lawyers. The reality is it's the consumers is why they don't hire lawyers or why they don't hire anybody else. But the liability has always been with the broker because of Conway Bogue, and them acting as a scrivener because of Conway Bogue. And so the reason that we wanted to change the language was to make it so it was specific, so that it's coming out of their Schedule B2 exceptions and not something that you have to go to a lawyer to figure out which ones go in there.
And I'm not against that. I mean, I haven't seen it since assumptions.
Yeah.
my next project that I'm working on a little bit is I'm trying to look at other states, because a lot of other states they don't have the Scrivener's fiction that we've created here. A lot of other states have statutory authorizations for title companies that would allow them to prepare the deed on a deed that they're on the underlying deed for which they're writing insurance on, which I think makes a lot of sense. And so, that's a pipe dream, but that might be part of some other negotiation that we can work through. So I would like to see that is us adopt some authorizing language. The problem is that everybody talks about Conway Bogue, but the companion case to that was this title guarantee case, which basically was the Supreme Court on the same day saying title companies cannot prepare deeds. And so we've just lived under that, and in response to that created this Scrivener's fiction, which is nothing more than a fiction. But the problem with that is that brokers have become, this much further negligent in their practice because they're not paying attention to deeds. They're not even reviewing legal descriptions oftentimes. And they maintain primary liability for for everything that goes wrong. So hopefully there'll be some changes.
Yeah, I would love that. I mean, if the brokers, I represent brokers. If the brokers aren't responsible for the deed, I don't care what they do with it. That's the way I look at it. So I have one more form. You want to talk about personal property agreement?
You talk about it. That's your baby.
That's my baby, yes. So I'm going to get yelled at, but John, you want to leave? So guys, I'll tell you what this form is for. So the story is if up in the mountains, Vail, Telluride, Aspen, those places, they do a lot of fully furnished units that they sell. And when they go and they sell these units, and they list out all of the furniture and everything else that's going with it in the personal property, and they send it over to the lender, what happens is the lender turns around and says, oh, you guys got to take that out of the contract because we can't have that in there because then otherwise there's value being assigned to the personal property and you got to do something different. And sometimes they tell them, yeah, just put it in at zero value when in reality it's worth thousands of dollars. Or sometimes they tell them, go put it on a bill of sale and just put on the bill of sale $1 and don't tell us about it and then commit loan fraud and it'll all be good. That's where this comes from. Now, whether it has application in other places on the Front Range or other transactions that are not the fully furnished units, I don't know, and I think it may. But the purpose being is that right now you have this problem of the buyer wants the personal property, but they don't know how to get it when their lender says take it out of the contract. And so one of the documents that we created, and we tried to create this last year and got shot down, but it's coming up this year, thanks to changes to the standard forms legislation that was passed, is that it's a personal property agreement. And the way it would work is this, is that if it's a fully furnished unit, you would have a contract for the purchase of the real estate, you'd have a contract for the purchase of the personal property, they'd be tied to each other that you don't close one without the other, but at least that way there would be this allocation of cost to the personal property versus cost to the real estate, so that the lender could still close on the real estate based on the real estate contract. Buyer would have assurance they're getting the furniture they were getting, but they'd have to pay the fair market value for it at closing. And at least that way we're bifurcating those two problems to help hopefully fix the problem up in the mountains with the lenders.
And avoid loan fraud.
And avoid loan fraud.
Which
Yeah,
is
potential loan fraud, as I was told yesterday.
Which is, from my perspective, the biggest issue.
Yeah, absolutely. I mean, that's the reason for doing this. It also makes it so that the lenders have, or at least the brokers have a mechanism for dealing with the lenders when they say not to put it in. I don't know what else to say about that form other than it's really cool.
There you go.
All right. Oh, look at that. John's got a question.
A comment.
Would that also, I only see it occasionally, not very often, where that same scenario happens here in town with
Yes.
appliances.
Appliances or hot tubs or televisions
Take that
or
out of the contract.
pool tables.
Well, and we saw it a lot more when it was back in 2009 and 10 or whatever, when the lending market was really tight and everybody was cracking down and making sure. So you absolutely saw it come out. You know, the rub is going to be this, and this is where my biggest concern is with this, and I think you would agree, is that, oh, pull it out of the contract. So we put it in a personal property agreement. We put that it's worth $1 because we're just trying to hide it from the lender, and that way we can document the fact that we committed loan fraud. And that's the one scare I have about this form, is that you still, if you're pulling appliances, you're pulling hot tubs, you're pulling whatever else out, if the buyer wants assurance that they're going to get the personal property, then they have to pay for it. And that means not $1. It means real money. Now, if the buyer wants to take the chance that the seller may or may not leave the personal property after they leave and abandon it, you don't have to put anything in, and hopefully they abandon it. But if the seller takes it with them, they take it with them.
There's no disclosure requirement. If there's no agreement, there's nothing to disclose to a lender. But
Right, but it means that you're taking the risk that the seller could decide, you know what, I am going to take that hot tub with me. Yes.
Here's where I see a problem.
Uh-oh, because it's already done.
The comparables are set by what's existing, what's happened. Those sales that those agents are working with, and they're pulling comparables for your condo that you want to sell, were all sold with the furniture in them. How are you going to establish the value of your condo without the furnishings, and how is it going to be perceived by the other people in the complex who see their values going down because, oh, okay, $750,000 with it furnished, furniture's worth $50,000, $700 for your condo, $50,000 for the furniture. You just hurt my property values.
Well, first of all, I don't think we have a duty to those people. Second of all, most times the people that have the quote at $750,000, that's what they're basing the real estate on. Because in theory, it's not supposed to include personal property. And so if it did include personal property, as far as the assessed value or anything, if you look at assessors, they're supposed to list it in that transfer, the real property transfer declaration too, the TD 1000. So I don't know if that's going to be a real major problem. I really don't. I think the bigger problem is just making sure brokers understand this is not just a, oh, we'll just put $1 and do it outside of closing and call it separate. And that's really the bigger issue there.
Yeah.
I think it could be an interesting conversation with your resort area brokers to get their perspective. Because Damien, I see where you're looking at it from a very legitimate perspective, and Scott also with the loan fraud. But I see it creating a real working problem for them.
Wouldn't they be able to still
least
list it at
transitioning
$750?
into it through the period.
Well, and I certainly understand that too, but I would still think they list it at $750, even if it includes personal property and it's worth $750, it's worth $750. And then when you sell it, you could sell it at $750 and say there's $25,000 or $50,000 in personal property involved. There's got to be a mechanism for making that work. I hear what you're saying, but there's got to be a mechanism.
The problem, anybody in this room has probably heard me gripe about fickle lenders, but you just don't know as a broker when you write a contract and you send it over or you send over an inspection resolution, you don't know what you're going to get from the underwriter. And oftentimes it's because the conversation hasn't been had early enough in the process. And so I know this market's, velocity, and it's like, hey, we don't have time, we got to get our offer in, we don't have time to have our buyer check with their lender to see what's going to be acceptable to the underwriter. But that would take care of so much of this if there's that early conversation.
Absolutely.
But it is problematic for brokers if they're helping perpetuate loan fraud, either, well, certainly knowingly. You've got license law violations potentially there, and you're subjecting your client to who signs at the loan application phase. They have a statement. It's buried in the legalese. It says everything's going to be presented to the lender for their consideration, any contract documents. And then they show up at closing, and all you guys know, they sign a form that says everything's right here on the settlement statement. And if that's not the case and you haven't made disclosures to lenders, I think it puts brokers in peril. And that's what I worry about primarily.
So you're saying that what'd you call it,
Personal property agreement.
Okay, so that, with a 50,000, we'll use Ann's number, so that should go to the lender.
I don't think it has to. I will tell you that I want a disclosure that says that there is one, and if the lender asks for it, they can have it.
Because as soon as you do that, I think what Ann is trying to get to is the lender's going to pull out that 50,000.
Well,
Okay, now your value is
but
700.
Here's the thing. Let's say it's listed at $750,000. Let's say that the real property or the personal property, 50 sounds high, but we'll call it 50,000. Let's say that the seller or the buyer's going to pay the 50,000. Well, the price on the real property is 700,000. And so when the lender gets this and gets notice that there's a personal property agreement, they want to see it, they can see it, but it shows that they're paying $50,000 for the personal property. It shouldn't hang up the loan at that point because they're paying real money. Do you see what I'm saying? Because they can't pull it out because it's already pulled out.
So I think it's, the difference is attorney land and real world land, yeah.
I've actually had this form used in several of my offices that are in different mountain communities, and they've been using it for 4 or 5 years, and it hasn't been a problem with the lenders. Now, whether it stays that way or not, I don't know. And whether all of them are using it or not, I don't know.
And it is not becoming a mandatory form in any sense. The personal property will still remain, the provision is written, it will still remain in the contract to buy and sell. That's not going away in reference to personal property. I think there's going to be a checkbox. Is that what we came up with?
Yeah, I think that's what we came up
So
with.
there's some kind of checkbox that says there is a personal property agreement or there is not a personal property agreement, which takes care of the disclosure. What are you laughing at me for, Jen?
You don't like checkboxes.
You just said you don't like checkboxes.
No, we didn't like those check boxes. We love other check boxes.
What? No, I didn't say I didn't like checkboxes.
No, the ones at the bottom, the rejected
Oh,
encounter.
no. Well, those.
Those are dumb check boxes.
Well, they don't have contractual significance.
Exactly.
Checkboxes. The checkboxes that I'm talking about have contractual significance, which I like.
Just trying to keep up with you, Scott.
I'm actually curious from you guys, from a practical perspective. I mean, let's say that you write a contract that has personal property included and you're not making, because invariably, if you're going to have a laundry list of personal property in the contract and that goes to the underwriter, what do you hear? Get it out of the contract.
Take it out of the contract.
So what do you do now? And where do you
Where
put
do
it?
you
Where does
put
it
it?
go? It goes in a bill of sale.
Oh,
And then,
at the time of contract, do you do a bill of sale?
Goes on a-
No, typically, if
So the
it's only
buyer
a
and
few
seller
items, the
would agree.
lenders don't even call it out.
No,
Say-
that's
say that
fine,
one
but
more
if they
time?
tell you to take it out and put it on a bill of sale, and you do it at the time of contract, and the contract fails, does that mean the buyer owns the property?
Yeah, it's just an agreement between the buyer and
Think
the
so.
seller that the buyer is going to get that furniture once he closes.
What's the agreement called?
It's between the buyer and seller, I have no idea.
It's called a side agreement.
Oh, there you go.
that's the word. That's the word.
The side agreement that says that, hey,
And side agreements in and of themselves are not illegal. It's an undisclosed side agreement that you get into problems.
and particularly the ones that's for $1 wink wink because we want the loan to cover the actual price of the personal property. That's where the issue is. So, I don't have any more documents to talk about. I guess I'll let you go.
No, I don't. Well, yeah, and I don't have. I mean, that's.
Are you done with your list? I'm done with my list.
Well, and then I had some other just kind of notes on there. I mean, I don't know what you guys are. You ask questions, or you can tell us to beat it, or you can. I've got some other topics.
Number one, Scott, your top 3 or 4 items of the legal hotline, your items right there, and then any questions that you all have.
Okay, top 3 or 4 items on the legal hotline. I mean, number one is always and always will be some, in terms of call volume, something related to earnest money dispute, either a brewing earnest money dispute, or may have, we've got one, we may have one, I feel like we're going to get one. Seller's not releasing earnest money, and I'm getting a lot of that in what I just consider to be flat out bad faith. And I don't know how we solve it, but I don't like the way the contract says a seller is supposed to return earnest money within 3 days of receipt of, but there's but what? What?
Unless he says, I want the money, and then all of a sudden it's a dispute, and we have to go through the rigmarole.
Then you go through the mediation and potentially a claim or whatever. But what ends up happening is they just don't return it, right? And we actually see ethics complaints, and I feel bad because you get listing brokers who they're doing what they can, but they can't force their seller to sign an earnest money receipt. And then the buyer ends up trying to use our process to file an ethics complaint against the realtor against the listing realtor because they haven't gotten the earnest money back in any timely fashion. They're trying to use other forms of leverage, which I've got problems with that process as well. So earnest money is always the single biggest, and then the kind of tertiary items that are related to earnest money dispute. What's the process for mediation? What's the earnest money holder's obligation? And I think that's actually a really good point that comes out of the ACU, and I know that was probably one of your inclusions in this year's commission update course. This concept of using closing instructions and using our form closing instructions and getting them done, I believe, at the time of contract. And I know you feel the same way.
Absolutely.
And because if you have an earnest money dispute and you haven't signed earnest money or closing instructions, or they're taking place at closing, guess what? Paragraph 24 of the contract really doesn't apply to the earnest money holder because they haven't been tied to the contract in that way. So yet another reason I think it's important for the protection of either of your clients to make sure that an earnest money holder is confined to those kind of 3 options that they're confined to in the contract. And if you're not doing closing instructions early, then that's a big issue. What is any hotline?
I got one.
Go for it.
Appraisal guarantees. You get that one a lot?
Appraisal guarantees? Clauses you mean?
Yeah,
like
clauses
matching?
that say that the buyer will pay up to $10,000 over appraised value, and people not putting ceilings and floors on the limitations as to what the buyer and the seller are going to pay. Or my favorite was the other day, the clause just said, buyer will pay $5,000 over appraised value.
I get that all the time.
Well, what was nice is then it appraised high or something, and the buyer says, well, I want out, or it appraised low, or the seller says, wait a minute, the appraisal provision doesn't even count anymore because you've already agreed as to what's happening. So tough, great you got an appraisal, now you just set the price. And it's amazing to me. The other thing that bothers me is that we have these, sellers are crazy, and so are buyers. I mean, they're all crazy right now for some reason. This is what's going on, is you have sellers who think that they should get more out of their house than what it's worth. My house should be worth more than what the market says it's worth. That's what every seller thinks. And every buyer thinks, well, if I'm paying more than what it's worth, then it should be perfect. And you guys have a really, really, really tough job right now because you have to manage the expectations of all these consumers because these consumers are crazy. And I don't know how you do it, but seriously, that is, to me, the biggest thing that you guys can do is try and start at the beginning of the buyer relationship or right at the beginning of the listing contract about the fact of, look, I know that it might get bid up over this, but we still have to appraise. And even when we have appraisal guarantees that say they'll pay over this, that means that if they don't, you get earnest money, and that's it. You know, there's risks here. And just because the buyer says he wants to pay over the appraised value doesn't mean his lender is going to be okay with it. And it's just these limitations that these buyers and sellers have to understand when they enter into these contracts that, you know, I know it sounds good, but that's not the way this always goes. That's the big one I see. But
yeah, appraisal clauses are bad. And then you made reference to it, but one of the more common calls I get as well is that a listing agent that calls and feels that this appraisal matching clause, a buyer's agent that calls and says that the buyer's commitment to bring additional money sets the purchase price. In other words, let's say you've got a purchase price on the contract of $300,000, and the clause, a properly drafted appraisal matching clause against the buyer, says buyer agrees to bring an additional $5,000 over appraisal to the closing.
Up to the purchase price, provided it appraises for a minimum of.
And so then it appraises for, let's say it appraises for, $280 in that example. And so now they've got to bring $290 is what they'd have to bring, right? There's this belief then that the seller would have to sell at $290.
Yeah.
Right? Because it's not a two-way clause. It's an obligation on the buyer to do that, but it doesn't necessarily obligate the seller to do that. And so if you're writing these clauses, I think this gets left out a lot, that the proper way to say it is purchase price shall be changed to, rather than this expectation that the seller is going to have to cave and bring their price down. So it's got to be written as a two-way obligation rather than just a one-way obligation. And I get buyer's agents that call all the time and say the sellers say they're not going to match this purchase price. And I say, well, you read me the clause. I'm not really hearing that that's their obligation, because it doesn't say that they're going to change the purchase price. It just obligates the buyer to bring additional money.
And even if you're changing the purchase price, you better have a requirement in there that the seller's got to sign an amend extend, because otherwise the lender isn't going to.
Yeah.
I mean, they're complicated.
So that's another one that I feel like I get a lot from buyers. So anyhow, a couple other things that I'll throw topics out. And Gary mentioned it, broker supervision. It's a hot, commissioners' eyes or antenna are very high on broker supervision issues. I don't always stay, because the meetings get so long, I don't always stay through all of the complaints, but it's almost invariably that if there is a complaint against a broker, one of the first questions is there supervisorial issues related to that? And so, for those of you that are employing managing brokers, be mindful. There's a perception out there, and I've had employing brokers call the hotline and argue with me that they really only have a high level, or that they have a high level supervision for broker associates 2 years or less, but then the rest of it just kind of goes away. Well, there is a reasonable level of supervision, and so there's a real, like I say, cynicism, I would say, among segments of the commission related to broker competency and supervision, and so I would. Be mindful of that. The other thing that we've talked about a little bit is and I've heard it, and I've heard, I haven't just talked to Damien about this, I've talked to other attorneys that represent brokers in front of the commission, and that is that there's also a very eager investigation into
plug your ears, Gary.
Every aspect of the file. In other words, if a complaint comes in, it's limited to a transaction or a specific portion of the transaction. Once that complaint gets assigned to an investigator, that entire transaction becomes open to review, right? Including any derivative supervisorial issues that may come from that. And I think that goes on quite a bit. I won't ask Gary to comment, and you probably, this isn't even really your niche.
I don't think it's his at least it's not his.
But I mean, I've heard it from Damien. I've heard it from from a couple of other brokers that prominently represent. A couple of other attorneys that prominently represent brokers on these kinds of disputes, that there's a willingness among the investigators to really get into a much broader area of that broker's practice and that the employing broker's practice beyond just the complaint, and more so than in the past, I guess is how I would say.
Yes, they've been very eager to review things, I think is the way I...
The only other thing I had on here was, you'll kill me probably, but...
Oh, good.
Education Task Force, Damien's on that. And so if you guys have thoughts about education, or
Do not send it to Damien.
What would
Send
go-
it to Gary.
send it to Gary. But those ACUs, I was saying this morning in an interprofessional meeting that I think they've gotten a lot better, and it's reflective of, you know, them. The last couple of education, or of 4-hour mandatory update classes, I think have been much better than they had been in terms of giving, you know, good brokers good practical information, practice information, risk management information, and so they've been good, and I think they will continue to be good. But if there are issues that you want the Education Task Force to consider, and I don't do anything, so don't send anything to me on this. But if there are issues,
can, though.
Then make sure you're chiming in on those things, because the division, I say this all the time, I say it in front of Marcia, I say it in front of Gary, we are fortunate in our licensed vertical as licensees, real estate licensees, that we have the division and the division staff that we do. They are very collaborative, practical, pragmatic, and so we could do much worse, but they do listen and they are responsive to things like that. So do contribute if there are thoughts that you have in that regard. I will always take topics from my Legal Bites series, because I'm always hunting for those. So if you do have topics, Jan's good about sending me stuff for those. Anyhow, I don't know. I don't have anything else.
I don't either.
We thank Scott and Damien. Any questions?
One thing I forgot about it, but it came up yesterday twice.
Here, do you want to talk?
Sure.
I'll stand right next to you.
Every once in a while,
You're gone, Scott. Good thing. Take the mic away. I've got to do a legislative update.
start letting other folks know as well as yourself, brokers, to Google your name and put -timeshare after. Yesterday alone, I got a call from the BBB, who I work closely with. I go to the Denver, the Colorado Springs, and the Fort Collins BBB quarterly meetings. So I hit them all. And the timeshare scams come and go all the time. But yesterday, the two calls were, they even had photos of the real estate brokers on the scam website. And of course, what we do, we're nice, we will call those brokers and ask, is this you? And we got a call that there's a scam, and they're like, oh my gosh, what do we do? So we try to direct them how to get websites taken down, things like that. But once your name gets on the BBB list, and once it's on the internet where it hardly ever goes away, that could wreck your reputation right there. So what's happening is, of course, what they're doing is going on our public information, looking up brokers who do not list a phone number or address publicly. Could be because you're inactive at the time, could be because you're updating, and those are the ones they look for, because the public cannot track you down then. So it's been a big problem, and we've had one broker even went on TV, Channel 7 News, to say this was not me. So you've really got to start doing that, because these are not going to go away.
What are they gaining by doing that?
Well, they're a timeshare scam. So what they're timeshare resellers. So then they think they're talking with a broker because they see your license on our website, and they think it's really you because now your picture's on the website, and they're going to send you $5,000-$10,000 up front in a money wire, and then you're the one that's going to get blamed for scamming them.
I've even seen, and I think I sent to Marcia, a broker called the hotline, and they had these fraudsters had actually created a card with a photo of some individual. It wasn't the broker, but it was an identification card that they were, and it said, Colorado Real Estate Licensee or Division of Real Estate Licensee. It looked very, very official kind of identification card with some random photo of a person, in a suit, and then all of the brokerage contact information. And they were using that to solicit timeshares, to solicit timeshare buyers in other states, like Colorado. And so, yeah, I've heard about a number of those situations.
Wow.
And even yesterday, after I had lunch with Marcia and Eric, I said, I'm going to go here because 2 blocks away is where their office was located. So of course I walked over, and in the basement I talked to the security team at the building, and they said there's nothing on the 8th floor because it's being remodeled. So they're smart enough. They're not smart enough to put an address far enough away from us where we just can't walk over. But they're making a lot of money, but they're wrecking brokers' reputations in the meantime. And I sat yesterday with the ARDA representatives, American Resort Developers Association, and they are now trying to do things out of Washington, D.C. to also have on their website, information that can help people, but it doesn't help you guys if they've already tainted your name and your reputation. So even the classes I used to do, I'd always say, hey, just go ahead, plug your name in every once in a while, put -timeshare, unless you're a timeshare salesperson, then that should be there. Otherwise, it's probably tied to an illegal reseller.
Thank you all. Now Scott's going to give us a very limited update on the legislature, and our last presentation will be by our CAR chair and chair-elect, Ann Hayes and Justin Knoll.
Okay, well, I am not Liz.
Definitely not Ted.
That guy. You get that back there? Sorry, I can never give up on kicking Ted around. I don't care how long he's gone. And so Liz gave me this. Liz has been fantastic, by the way. She's doing such a great job in stepping into Ted's, in all candor, big shoes, and she's done a phenomenal job. So I'm going to just hit on a couple of things, and then you guys are going to hit on a couple of things, or somebody else is going to hit on a couple of things. Bills that I think are probably interesting to this crew. First of all, Gary had mentioned the Sunset Review fix, we'll call it. That went through the House uncomfortably. Did you hear that testimony? You weren't there, did you hear it? It was uncomfortable. I got grilled in a manner I didn't expect to get grilled when I went to testify on a very innocuous amendment to the Sunset Bill. But that's just in relation to that transition period and our moving of licenses. And Gary alluded to the fact that the thought was to do the 4-hour transition course that every licensee that wasn't eligible for 2 ACUs in their less than 3-year compliance period, they would have to take a transition course. So we modified that language, and so that was creating all kinds of confusion. And you were hearing about it in your ACU class teaching. I was hearing about, well, it was also going to be limited to only DPOS schools were eligible to teach it. And so, like DMAR, as an example, wouldn't be able to host the transition course, which was reasonable considering the division also has to then go review and audit and everything else if they just open it up to everybody. But I was hearing from larger associations that wanted to teach it. They couldn't do that. We were hearing from smaller associations, more rural associations that didn't have access to live DPOS instruction. And so what we did is, and the division was supportive of this, we kind of worked this amendment with them, or worked it through them before we proposed it. But now in any license period of less than 3 years, which probably everybody is going to have in this transition phase, you only are required to have 2 ACU courses, or 8 total hours. You still have to have a total of 24 hours of education, but you have to have, but 16 of those hours then would be elective as opposed to just 12 hours of elective. Somebody did Gary was saying this morning that somebody already submitted a ACU course. Yeah, so or not an ACU, but a transition course. So you could still take a transition course. There's nothing that would prevent that. It would just go to your electives. But I think that bill is in the Senate. The hearing's next week on it. I'm cautiously going to go back. I don't know that I'm going to make any. I'm not going to testify, but because that was a hard House hearing on that bill. Gary was there for that.
You had teachers on
Yeah. Is that what was going on? That's funny. I didn't put that together, but.
So that 24 hours then is in the 2 years and 6 months.
2 year plus, yes.
Yeah, you still 2 year plus. You still have to have your full 24 hours, but you only have to have 8 of those be ACU.
The ACU every year, you're fine. That's really the.
Right, but instead of being but it's 24 in 2, let's call it 2 years and 6 months for a shortened, not, yeah, got it.
Your electives are the same, but shortened.
more elections.
Your total, yeah,
Yeah.
your total is the same.
The total is the same in a shortened amount of time.
Yeah, but if you take the ACU every year, it's fine.
There are a couple of affordable housing bills. I'm going to not get into too much other than to say that the one that where there was a document fee associated with that, we were successful in making go away. So everybody's trying to think creatively about affordable housing. It certainly is, under any analysis, an issue in the state and becoming probably an increasingly large issue. I won't go, I thought it was a very interesting discussion, by the way. We had an interprofessional meeting this morning and talked a little bit about these deed restrictions. And I've had a couple of hotline calls recently about a seller who had bought under a deed restriction of affordable housing, didn't acknowledge that, sold the house for much more money. And so do be mindful as a broker and for buyers and your sellers that they're paying attention if they do have deed restrictions. The more affordable housing we see, the more deed restrictions we see, the more we're going to see this problem occur. And it's a really nasty problem because I don't know what the solution is exactly at that point.
Rescind it 3 times.
Yeah, you're going to rescind a bunch of sales and.
This buyer back to this buyer.
So anyhow, be mindful of that. But affordable housing bills. The other bill that I want to talk about real quickly is, or the 2 bills, and there's apparently a third one coming that I've got some real problems with, and I sent Ann an email about this as well. But these arbitration bills that are out there floating around and are probably going to come out of the House. Their hearing is next week on the arbitration bills in the House, and they're going to get out of the House, is what the expectation is. But there's some very what I'll call onerous restrictions and limitations and burdens put on any arbitration service provider. And, well, ironically, the only arbitration services provider that are exempted out of these bills happen to be the labor unions, but I won't get political. But certainly CAR, DMAR in your professional standards arbitrations would be applicable. I had a conversation with Chris McGatt about it. Coldwell Banker, I know, has their own internal arbitrations. I think, does Keller Williams do? Keller does their internal stuff. I don't know, does RE/MAX do? Does anybody know, Jan? Yeah, so it would all be affected by this. And it puts some, I think, potential burdens on arbitration panelists. And God knows ours are all volunteer, members like you guys. The last thing you need, in addition to giving your time, is to create some, private injunctive rights against yourself by actually appearing or as a hearing panelist. It puts a lot of burdens on arbitration providers, which would be CAR or DMAR, including a 5-year rolling update on the website that would identify the parties, the result, all of this stuff that in our process is confidential, right? And so really, really problematic. Again, I have every confidence, that, according to Liz, that those bills are going to get killed in the Senate, and they will get out of the House probably next week. But we do have an election coming up in the fall, and there's a chance that the Senate goes another direction and that there's these arbitration bills might become more palatable in next year's legislative session. The third bill, which has not come yet, and Liz was describing to me this afternoon, is, and nobody's seen it, but apparently it's something to address the Bellagio stuff and to really have some implications on construction defects and all of the success we had last year. All of these bills, I think the subtext of it is basically we're nickeling and diming back on the construction defect stuff because arbitration became, the kind of centerpiece of that through the fixes we had last year. And this is a way to help, kind of pull some of those back. So I guess it's time to make an RPAC donation pitch based on the importance of the upcoming elections. But you all are participants anyhow, so I won't go there. But I don't mean to make light of that because those arbitration bills would have an impact on how we do our professional standards statewide, and DMAR, the larger associations, I think it's just only a couple really, including DMAR, that handle their own professional standards, would have an impact there too. And have you seen those bills, John?
No.
Okay.
I've heard, but
I'm happy to give you, I probably have a copy somewhere in my bag, so you might be interested in seeing those as well. What other bills are kind of floating around? Damien does a lot of bill tracking through the Bar Association. So is there something else that I'm? Squatters bill. Yeah, SB 15. This is coming out of Colorado Springs, and they're basing it on Washington law a peace officer or security personnel can remove a person with the owner's affidavit within 24 hours. So this is to address kind of vacant properties that have been taken over by a squatter, somebody with no real property right. Well, currently the solution to that is to go through the eviction process with the person. And so now this would allow, upon the owner's affidavit, to say, listen, this person has no property right, they never have, I don't have this, the eviction process shouldn't apply, then it would allow a much more truncated process to remove that person. So I think, again, certainly the association is supportive of that bill from a real property rights or property rights that is one of our sort of tenets. Then we would like to see that thing get passed. Liz mentioned there could be some possible amendments in the House. I asked her to send me her thoughts because she couldn't be here, and and that's what she's doing. The arbitration bills are being heard right now in the House, and so she's sitting in on that, and I'll listen to it later because we're going to need to be prepared for it next year. But I was going to say, so she sends me like 5 pages of typewritten notes. And I'm like, Liz, for these things, my hand, I write in the palm of my hand my chicken scratch and do this. But anyhow, Liz is doing a great job. Any other questions on legislation? You guys are going to hit on a few things, I think, too.
Okay, I'll touch on a couple more things for you. One of the other items going through CAR are the tax credits for philanthropic giving, and also the broadband, trying to get broadband for rural areas and throughout the state. There's also 2 limited growth bills that are out there. One is for Lakewood. That one only requires the voters of Lakewood to sign on to that. But the other one is a statewide bill that is being pushed quite heavily. CAR is a member of an organization called REMI, which is a coalition of a lot of players around the state. Tyrone and Larry McGee represent us on that coalition. They are spearheading the fight against the 1% growth around the state. The supporters of that bill would have to get 2% from every congressional district of registered voters to sign on to it. However, it is gaining a lot of impetus. So in response, CARPAC on Monday approved $250,000 as starting money to be prepared to join in the fight to stop this coalition attempt at the growth initiative. And we will be applying to NAR, to the Issues MOB Committee, for an additional $750,000 to get approved. We have to move ahead to get this now, because we need to get the monies in place. If we don't have to use them, that's wonderful. But if we don't have them, we won't have the ability to really take down the 1% growth initiative around the state the way it should be. And so that's what we're doing on that behalf. We will be going to a hearing with the Issues MOB Committee at the May meetings, and we'll know more then also about where this movement is going. But in case you haven't heard about the 1% growth, it would require individually in all the different districts approval of the voters to allow anything to be built, which could essentially stop construction. And seeing as how housing contributes 25% of the economy within the state of Colorado, that would not be good for Colorado. So that's where we are. Those are the things we're working on. We're having a very, very busy year at CAR. Our Legislative Policy Committee, which is now in session, they meet every 2 weeks, and they are currently reviewing 60 bills that are out there that potentially could have an effect on real estate. So compliment your legislative policy people when you have a chance. They spend a lot of time working on that behalf. Justin.
So on the national level, so obviously we're part of the tri-party agreement, national, state, and local associations. On the national side, a lot's happened over the last year with tax reform, all kinds of stuff. So I want to bring to you 6 key things that NAR is focused on right now. Top legislative priorities. Number one, multi-year reauthorization of the National Flood Insurance Program. So as you guys may or may not know, flood insurance, the can was kicked down the road after can after can. And it's just kind of backed itself into a corner. We're looking for a long-term solution on this, not such a temporary Band-Aid approach to it now. So that is something they are fighting for. And we've seen, obviously, with climate change, and believe it or not, it is happening and places are flooding. So it's a big problem. Number 2, ways to protect middle-class homeowners by improving the new tax law. I think number 1 to this, we've actually got to figure out what is in the tax law before we can work on the tax law. So we're anticipating over the next year or so is really just digging in and finding out the details of what it actually is and what it truly means. I don't know that many people know at this point. So it's an investigative thing. But I will tell you, and I know this group is pretty savvy, but without NAR and all the efforts that we have, this tax reform bill looks very different if we're not involved. I mean, just capital gains and mortgage interest deduction, I won't preach to you guys, but it's incredible the effect that we had on this and what potentially could have happened. So look for more on that. Number 3, responsible housing finance reform and the future of GSEs, or government-sponsored enterprise entities. And so we're looking at Fannie, Freddie, those kind of things. We're looking for a solid approach to this, where these are really good working pieces of government that really are helping our market. And we want to stand behind them. We want them to be in place. We think there's good things involved with them. It does make it hard when Fannie is showing a multi-million-dollar loss. It's not an easy thing, but we're still working on something for that. So look for more on that. Resolution of the Federal Communication, the repeal of the net neutrality. Excuse me, NAR's approach is if we're restricting times and speeds, it's going to force, I mean, there's 1.3 million members, 1.2 million members. Most of them probably have a website. Are we going to have to pay a premium, a higher price, to get back to normal or a higher speed in our, just to get on our websites, even not even our company ones, but individuals? So there's just so many layers to this. So that's something that NAR is definitely looking at. Inclusion of self-employed individuals in association health plans. Anybody here interested in that? Yeah. How we have this many members and not the ability to put this together is beyond me still after a whole lifetime in real estate. It just drives me crazy that we can't put this together. You would think there would be an easy way to do it. So that is definitely on the docket for NAR. Last but not least, the extension of important real estate tax relief extensions such as the mortgage debt cancellation relief. So this was extended through the tax reform bill. I don't know if it was certainly intended to be, but it was. So we're looking again, it's like flood insurance. We're looking for a more permanent resolution to this and to keep it in place, but have it more fixed, something that's actually a little more structured to it. So that's what NAR is working through. It is a challenge. Never mind your political beliefs. It is a challenge right now to get clarity on a lot of things. So that's a struggle. If you guys, anybody want more details on this stuff, if you haven't signed up for it, or you can, this is the Capital Connection, is a newsletter that goes out. Was it monthly? Weekly, 2 weeks. Yeah, right after LPC. That makes sense now. LPC, right after that, that's why I get them all the time. So Capital Connection, I can't be in all these meetings, you guys can't be in them. This is a great way to just debrief on everything really quickly, get some good boilerplate material that you can go talk about, discuss in your brokerages or with your clients or your friends or at the dinner table. If you want more details, email Cameron, who's new to our staff, at c.hill. C-Hill. Chill. You said the dot before. Chill at coloradorealtors.com. I want that email address. Chill. So there you go. That's what's happening on the NAR side of things. So we're working hard. We'll be back there in May for legislative meetings. Should be a fun. Anybody going? Who's going in this room? Should be a fun one. So stay tuned for more. I think that's it on our end. Good.